Hey, Stephen. The, the new forms actually were released July 1, or maybe it was 2. They are available for use in DocuSign and Zip Forms and Dotloop, depending on which program you like to use. I believe maybe in a couple of the programs, they still have the recent version in addition to the newly released version, which came out July 1 of 2022. So that's obviously the one that the commission would prefer you to start using. If you, for whatever reason, feel uncomfortable with that, you still have a grace period until the end of August to use the forms that were copyrighted in 2021. So it's okay if you use those, but they aren't available in all the programs. So just make you aware of that. We have obviously converted those over in the DocuSign checklist. They are now converted to the 2022 version. But if you have any questions about it, or if you need one of the other forms or whatever, let me know, or Carla know. Hopefully you'll just be receiving some of those. Right now, if you are a listing agent and you receive an offer on a 2021 form, you might ask if the buyer would be willing to put it on the new form. But for until the end of August, those forms are legal to use, just not the desired ones yet. So obviously they want to get us using the things that are most approved at this particular time. So like I say, I'm going to try to connect us now. As you can see, I can't talk and connect at the same time. Hold on a minute. All right, let's see. We're going to share our screen. And there they are. Looky there, right where they're supposed to be. Okay. Somebody was trying to get share. Here we go. Aha. There you are over on the side. Oh, what happened to you? Where did he go? I don't want that. Let's try again. Now that's better. Let's see. We want to enlarge this screen, obviously. We want the, there we go. Well, where'd they go? I thought they were right there. Hang in there with me. They were right there. There they are. Now we got the forms. We got the forms. We got the people. So let's see what we can get into first. Obviously, you know, the very first thing you've got to do is that working with real estate agents disclosure. For a number of years, it was a working with real estate agents brochure, and now it's a disclosure form. And the brochure has been turned into a questions and answers that is in a little pamphlet all its own. So this simple little form is the one that you will use now with every person you talk to, as long as it's the first substantial conversation you have with them. Okay. And that means if you start talking to them at all about what they want, their motivation, their qualification, anything that would have give you an advantage as far as being an agent with them, you want to keep in mind the rule. This is your first substantial contact you need to disclose to them how we work. Now, this form is your disclosure to them. This is not something that they need to respond to. They don't need to tell you what they want. You basically are saying, This is our disclosure from our firm and from me uh, of how we work with how real estate agents work in our firm. And the way we work in our firm is we can represent them as a buyer, obviously, in what would be called a single agency. It's just the agent working with the buyer, and it's not anything beyond that, where, um, in other words, you'll just work with them, like exclusively with them. Then you have something called dual agency. We offer dual agency. Our firm offers designated agency, and we're going to talk about that more today because the agency forms have changed to the good. They've made it a little bit more clear. But when you are talking to a client or a person initially, you want to tell them that we do offer all three of these. Now, I don't really care if you read this to them. It's simple and short. Sometimes people say, well, I don't feel comfortable with it yet. So can I read it? Sure, you can. The first thing I want you to point out to them is this right here. This form is required for use in all sales transactions, including residential and commercial. And look at the second thing we got highlighted. Obviously, they're not highlighted when you give them to your form, your prospective client, but just for your record, you can have this. And by the way, if you want me to send you a copy of these things, put your email in the chat box and I'll send it out to you. Okay. Where it says this form is not a contract, it's very scary right at first for most people when you start talking about forms. They are not sure what they're supposed to sign, what they're not going to. And so the first thing you want to do is set their mind at ease. All this is we are telling them how we agents in Keller Williams Valentine and in North Carolina work with prospective buyers. And it says here, you want to check these things. You check, they don't initial, you just check right here, and check right here. All right. I couldn't find a check mark in my Adobe program. I've got a new Adobe program and I couldn't find it. So I'll just tell you to put a check mark there. Okay. Then if you happen to be talking with someone who says, well, I think I'll just represent myself, then you come down to this box right here and you say you might want to be aware of this fact. If you choose to represent yourself, remember that other agent does not represent you. And so you might want to keep everything pretty much confidential to protect your own negotiating ability. So again, nothing broader than that. And look right here. This is new. For more information on the agent's duties and service, refer to the North Carolina Real Estate Commission's questions and answers. That's that brochure I was telling you about. And right now, we haven't been giving them out with everybody, but anybody who has extra questions, we do give the brochure. The brochure is available in the digital format, so you can email it to them or you can put it, in any format of, any program to send over to them. The other thing is they can now contact the Real Estate Commission and get a copy free of charge, and it'll be sent out to them. But I think you probably want to maintain the relationship. So I would suggest that you might have some of these brochures. They're pretty colorful. So you might want to keep some on hand, but again, they're available digitally. So all you have to do is put their email in and send it to them. You will get the buyer's signature on here. If there are two buyers, obviously both here, you'll put your name, your license number, and Keller Williams Valentine area right here. You're required to maintain those forms, okay? Those forms should be kept in a separate file. And if I were you, I would probably set up a loop or an opportunity in Command and keep multiples in there. You might not want to set up an opportunity for everyone you talk to and give this to, but if the commission were to send an investigator into the market center and require of me to show these working real estate agents brochure, or excuse me, disclosures, I need to be able to access them. That's why they really need to be in command in a folder for us. This is, like you said, this is a law. This is required. So you all help me out in that way, and at least have a folder or have some means whereby we can reach it. Okay. Now, the next thing I wanted to kind of go on, we're just going to work right through some of these forms. And please feel free. If you have a question, don't hesitate to unmute yourself and speak up, because you won't bother me at all in doing that. I just want you to get the information that you need. Now, the next thing you're going to talk to this buyer about, obviously, is going to be the exclusive buyer agency agreement. That's your employment agreement. Okay. Without this, you can't depend on getting paid. This is what allows you to write a contract until you have this buyer's agency agreement in place. Do not write an offer. You certainly cannot negotiate an offer, but make sure that you have this in place so that you know how to write the offer. If you don't know who you're representing, how you're going to write that offer in favor of that person. And verbal doesn't count. Okay. Verbal counts if you just want to work with them and show them property, but verbal doesn't count when it comes to writing offers. So make sure that you have the work with real estate agents disclosure form and the exclusive buyer agency agreement in place before you write the offer. Okay. Now, what you're going to do when you write the offer, you are going to want to make sure that you check on the listing agreement in Canopy. You want to look for the attachments and look to see whether or not the agent has posted the residential property disclosure and the mineral and oil and gas rights disclosure. And if the house is older than 1978, remember, you need the lead-based disclosure. So this offer to purchase is going to imply strongly that the agent should provide those ahead of time. So we'll talk about it a little bit more as we're getting to the place of writing the offer. But right now, let's just write the buyer agency agreement. As my,
I'm sorry, can I interrupt?
Sure.
This is Nicole.
Hey.
I know you're sharing the screen, but it's not loading up on our end. So we just still see your files that are on your desktop.
Oh, really?
So I think it got stuck loading.
Oh, thank you for letting me know. Let me see.
So
let's try this again, Nicole.
Okay.
Thank you, dear. Okay. You don't need to see all those things, do you? Hold on a minute. Let me stop sharing. Let's try again. All right.
Okay. I'll let you know when it pulls up.
Oh, please do. Please do. Okay. Now I'm going to get out of this and let's see if we can come into it again. Okay. No, we don't want to. All right, we're going to try this. Oh, that. See, it got in that right there. It's where it got stuck, I do believe. Let's see. Let's see if it can come in here. Do you see it?
Not yet.
Really?
Maybe.
That's weird. Oh, this would be terrible. Let's see, because that's exactly where. Okay.
Do you have dual screens?
No. Let's see. That one right there is, I do believe, where we got stuck. Well, it says I could do control multiple screens. Let's see if that works. No, that's not working either. Okay, let me see. That is so weird. And you're still not seeing it, right?
I don't.
Well, and you're the one who has on. Okay. How about, I hate to ask you to do this, but how about if I just log totally out and log back in? Because it does seem like it's stuck in that post, whatever, for a screen that came up.
Okay,
Would y'all mind doing that for me?
that's fine.
Thank you.
Okay.
I don't know anything else to do, quite honestly. Hey, Daisy.
Hello, Tabor. Good afternoon.
Yeah, hey, honey. We're having trouble with my sharing screen, so I had everybody log out and come back. Ah, there's Nicole. Okay. We'll wait a little bit and see if we can get another in here.
Okay.
There's Stephen. Okay. Daisy's here. Okay, let's see if this works. That is just the weirdest thing. But there was a post attendee thing that was stuck on there, and that's what I was thinking that might have been causing our problem. Do you see anything?
Yes, it's
Yes. Oh my goodness, all this technology. I tell you what, the technology is not my forte, but we have to use it every day, don't we? Yeah, it's like anything else, you know, that I always say, if it doesn't work, turn it off and start again. And
yeah, no, yeah, that, it usually works. Yeah, it usually does the trick.
Oh, I like it. I'm glad we had an alternative. All right, now let's see. I brought up the sample I was going to show you, but you don't need that yet. Let's see. Okay, let me see what I need to do here to get the right form for us. just when I thought I had it done. You all are being awfully patient with me. Hang in there. Where is the how are the forms? That is so weird. Well, I don't know how to get that other form up, okay, as you can tell. I would just do it one at a time. I had it all in multiples, but I know how to do it that way. Okay, we're going to go to the buyer's agency agreement first. But not that one. We want the buyer's agency agreement, not the non one. Okay. Do you see it? The buyer's agency agreement?
Yes.
Oh, we'll have to do it one at a time. And you know what? I took the time to highlight everything for us. Well, I'm sorry. I don't know where it went, but anyway, I know how to get through it without highlights. You'll just have to highlight it, I guess, on your own. The buyer agency agreement, as I said, is what you want to put in place before you write your offer. And notice that the buyer agency agreement is between the buyer and the firm. It's not with you as an individual agent, okay? It's going to be right here is where you're going to put Keller Williams Ballantyne area, all right? The buyer's name would go here if, and notice a little note here, that's what I'm getting ready to explain. There's a little note. Every now and then you do something, in fact, I'm seeing it more and more, where you're working with a buyer who might be an LLC, or it might be a trust. We see more of the sales side from the trust or an estate, but for the buyer agency, we're seeing a lot of LLCs. So if your buyer is a member, or hopefully the manager of the LLC, then right here as the buyer, you would list the name of the LLC and the word buy, BY, and your buyer's name. And again, it should be comma manager. Managers are the ones who sign for LLCs. A member of an LLC, unless they're a member manager, would not be allowed to sign. So what we really like to do is to see something in writing. They have the right to, legally sign for them. But anyway, just be aware of that. So if you're going to be working with LLC, you would put the LLC's name. Now, again, this reminds you, anything you see that's in the blue box, that is kind of like be aware of, just a note. If it's in red, then you're going to see the word warning, and you really need to pay attention to that. All right, we'll see some of those as we go through this thing too. One of the things that I think that should be in a warning box is this right here, that first paragraph, that first sentence. Buyer represents that as of the commencement date of this agreement, the buyer is not a party to a buyer representation agreement with any other firm. That means they haven't signed paperwork with somebody else, and now they're trying to work with you, okay? Sometimes buyers don't honestly understand that they have signed a buyer representation agreement, such as an exclusive buyer agency agreement. So you might need to explain a little bit to them and show them this document and say, have you signed this agreement with anybody else? Because if you do, I don't want to sign you up on this agreement, because that obligates you to 2 commissions. And hopefully that will build trust in them that you're looking out for them. Obviously, you're looking out for you not to be able to be in that scenario, because that's a conflict. So if the buyer signs agreement with you and they have signed with someone else and you selling a house, then you're probably going to get into a conflict over that buyer. So it's better to face it right up front, and help them to understand they could owe 2 commissions, or at least a referral fee, if they are in an agreement with somebody else. So like I said, I think that should be in red. And to the point that sometimes when I'm doing these things by hand, I have them to initial this paragraph that I talked to them about that. So, and they said, no, they're not in another agreement. But anyway, obviously it's in bold, so it means to pay attention, but I really want you to make them pay attention to that. When you're doing the type of property, you are 99% of the time are going to be residential, all right, because you are representing clients on home purchases, okay? You should not be doing commercial. We have a team that does commercial. We are not, we are residential agents primarily. This word right here, general, keep in mind that general means general, all right? It does not mean for you to put Pineville, Matthews, South Charlotte. Don't be that specific. If I were you, I would say Mecklenburg County and surrounding counties. If you also are licensed in South Carolina, you can put Mecklenburg County and surrounding counties, including York and Lancaster County, South Carolina. Don't put it if you're not licensed down there, though. That way you can at least go across the line to show a property. But then once you do identify a property, you're going to have to do all the South Carolina forms. All that, this is a sidebar. Okay, now back to North Carolina. Mecklenburg and surrounding counties is going to cover you broadly in case someone starts in South Charlotte and winds up in Statesville. Okay, so I would use, again, a general location. I've got stories about everything that I tell you, because we've had somebody get caught in it. That's why I say general, because we did have an agent get caught in that. Let's come down to the term of the agreement. Every contract has to have a beginning and an end date, or it's not valid. All right. So typically your beginning date is going to be the day you sign this. All right. That would be your begin date. Now you have two options here. One is that it will end when the house or the transaction is closed, when on a single property. Every now and then you may be working with someone, particularly like that LLC, you may be working with someone who wants to purchase more than one property. So in that situation, you would check the second box and possibly do it for a year at a time. Okay. Whereas on this blank here, you would not want to put a whole year. You most likely, you may get it done in 6 months with this multiple offer situation that we deal with, but 3 to 6 months is more typical. What just a single property, and that agency agreement expires at the time of closing and or this date. All right, so make sure you have a date either right here with a check mark or right here with a check mark. The compensation that the firm expects is going to be obviously your next paragraph or provision. The compensation in years past has been pretty much across the board 3% that the buyer's agent would be expected to receive. Unfortunately, that has changed a lot the last 6 or 8, 10 months. We now are not seeing that many buyer agencies offered in MLS at 3%. We are still seeing some. So if I were you, I would still put 3%, but you explain to the buyer that because there are a number of firms and agents who are not now offering the 3%, you have some options here. What you're going to do is your first way of trying to get paid is this one. The firm shall seek the fee from a cooperating listing firm. In other words, the MLS. If the MLS, let's say you ask for 3%, if the MLS offers 2.5%, most of the time we accept that because that's what they're offering. If perchance they're offering 1.5 or less, I saw one the other day that was $1 to the buyer's agency agreement. I thought, have you lost your mind? But unfortunately, the Department of Justice is wanting that to be more the norm instead of the what we see more often. So, but if it's an unreasonably small amount, then you have the right to go back to the buyer and ask the buyer to make up the difference. And sometimes buyers are going to be disgruntled about that, but you work for a living just like they work for a living. And when you work for a living, you have the right to anticipate certain income. And obviously after you share with Uncle Sam and the firm, there's going to be some you've got to make sure that you make a living at this. So just make sure that they understand. And again, you'll develop in your coaching classes, you're going to develop some scripts as to how to convey this. But from the legal standpoint, basically the buyer would be responsible. Now, if you were getting too much pushback, you might want to even say instead of put 3% there, I don't have a problem if you put 2.5. Do not go less than that though. Okay. So I think so I think you deserve to be paid. All right. So I would probably put 2.5% here right now. And let me show you one thing. I skipped over this line right here. Put an NA there. We don't do non-refundable retainers. I think we've had 1 or 2 agents try it. It's not common in our area, so therefore it's rarely acceptable to most people. So put an NA there. And then right here's where you're going to put that 2.5 or 3%, okay, whichever you feel comfortable and your buyer is agreeing to. Now, this is the first way we seek to get paid. This is another way that we seek to get paid. There are times that, let's say the buyer's agent is offering 1.5% instead of 2.5 or 3%. And what we would do in this case, we would use the form 220. Make a note of that. That is a confirmation of compensation when the compensation is different than what's offered to you. So you might use that form 220 to give to the listing agent requesting. You can't require or demand, but you can request an increase. You can ask them if they would be willing. Let's say they're 2.5 and you want 3. You can ask for the 3%. It is totally up to that firm if they will share that extra 0.5% with you. And on that particular form, there is a signature for you that you represent the KW Ballantyne and the agent that represents the other firm. So you might want to take a look at that form and see if it's something that you want to use. Again, if they offer a significantly low buyer's agency agreement. We have one team in our firm that does not share handsomely, and the answer always is that if the buyer's agent asks, they are willing to consider offering more. So get familiar with that form 220. The other thing here is, this right here is additional compensation. Let's say up here you did 2.5% instead of 3. You did 2.5, and lo and behold, your buyer was nice enough to buy or try to buy a house that has a 3% commission. So in that case, you're going to get paid more than the buyer agreed to. So you would use form 770, and it's at the top of the next page. See right here, 770. You might want to use 770 to disclose to them that you're going to get 3% on this. That doesn't say they have to do anything. It just says you have to disclose it to them if you get more than what they agreed to. Okay. All right. This next section right here, this is called a protection period. A protection period is that period after the buyer's agency agreement expires. That's why you have to have the expiration date. It expires, or for whatever reason, you might have terminated it. And beyond termination and beyond expiration, you will have X number of days that if your buyer decides to go work with somebody else, then you might have a right to be paid on any property you showed that client. What happens most of the time in that situation is they go to another buyer's agent, and once they go to another buyer's agent and get another agreement signed after this one expires or is terminated, then all bets are off. It's not a protection period. But just so you know, and you can explain to them that if they saw a FSBO and they thought they would cut you out and they would go around you and go to work with the FSBO, you still would be entitled to be paid out of that transaction. This is the meat of this agreement. So get comfortable with the way you explain it, get comfortable with the way you hope that it will be received, and say it in such a way that you don't cause pushback. And if they push back, then you would just answer, as confidently and as honestly as you can, because that's the way you're going to be dealing with them. Okay. All right. This is a kind of interesting statement right here. The compensation will be due and payable at distribution of proceeds from the sale of the property by the closing attorney or upon the buyer's default. However, you earn it when you go under contract. Isn't that interesting? You get a delayed payment, but you earn it when you go under contract. Okay. Now let's scoot on down here a little ways. This is a question we get sometimes on other potential buyers. Yes, our firm can represent other buyers on that property. We are exclusively working with this buyer, and you would be exclusively working with this buyer. However, that doesn't mean that other offers can't be placed on that same property by someone else in the firm. So every now and then you just get that question asked. It's not a big deal, but just if you're asked, you know the answer. Now they have rearranged a few things on this form, which I think really, again, it's clarification, and I really like it. The firm's duties, they have kind of itemized them here. You know, you learned in pre-licensing that we have something called fiduciary duties. Remember that term, fiduciary duties. And you'll probably remember the acronym. Remember old car? Remember they taught you the fiduciary duties by the acronym of old car? Well, the form writers have customized it a little bit, but basically telling the fiduciary duties right here. You have some general duties. You have the main thing, which is this confidentiality, the loyalty and confidentiality, and the standard of care in which you're going to treat everybody honestly and not knowingly give false information, which I think is a good thing to point out to them. Years ago, it was called honestly and fairly, and they took the word fairly out because you know what, you're in competition, it's not necessarily fair. So it's honestly, but not causing anyone else to get false information. Representation of others. This is again reinforcing that the firm could show the property to other people, but that would not interfere with your offer. And this is good. The submission of information to the listing service. Once you close, all that information is going to be posted in MLS, and it'll be there for a long time. So that all, including the sales price. Someone asked not too long ago, is there a way you can keep the sales price out? And I said, no, because that's public information. You know, it's registered at the Register of Deeds for the county. It's public information, and it is, it has to be available publicly. This right here would be the disclosure of the buyer's name and mailing address. We're not going to disclose that to other folks, but we have to have it, okay? And I'm going to show you where we get it in a moment. This next section is about fair housing. We do have to honor, and we choose to honor, the fair housing regulations of our country. And we will not show partiality or cause any problems for people who are in the protected classes of the fair housing regulation. Now this one here, look at there, so that's red. You see the word warning in red? This buyer's letters to sellers. My gracious, we're not seeing as many now because the commission has come out warning us that often in those love letters, that's what we call them, love letters, there are fair housing violations. Not meaning to be violating, but what buyers are trying to do is relate to the seller so that maybe they can get some favor from the seller, and in the multiple offer situation that they would choose their offer. But as they are relating, they are often violating one of these protected classes. And one of the ones that's most violated is the word children. How many times have I seen these letters that would say, my children are going to love playing in the backyard, or my children are going to love being across the street from the pool. And you cannot talk about children. That is part of the fair housing violation. Okay, so something as simple as that. So be very cautious if your buyer wants to write a letter. you're going to, again, advise them on the fair housing issue, and that you would not be responsible to convey that love letter or that letter to the listing agent. If they choose in any other way to get that information, that's up to them. But you can't be party to violating fair housing, okay? Now, the duties, again, they're outlined nicely. Instead of being spread out in a paragraph like this, which is obviously legible, but it's more clearly seen, itemized in this way. Now, right here, I was going to show you complying with reasonable requests of the firm to supply any pertinent financial or personal data needed to fulfill the terms of the agreement. Every now and then you're asked for a proof of funds letter. And because, right, if you have an offer to present and the seller wants to know, well, maybe you're presenting a cash offer. The seller has a right to know where, if those funds are readily available or where they're coming from. So at times you're going to have to ask the buyer to give proof of where the funds would be coming from. I had one, in fact, we're dealing with it right now, yesterday and today. One of my agents was dealing with needing to show proof of funds, and then the funds are going to come out of a house that is being sold. And the contract, it's in South Carolina, their contract is contingent upon sale of the house. And it seems obvious to us, but every now and then that other agent wants to know, okay, are there other funds? Can they really close without the contingency? So all that to say, just make sure the buyer understands that at times it's not you being nosy, you just have to supply those, okay? Down here, this is a change in this year's contract. I don't know if you've seen the previous contract. I think some of you have. I know you recognize your names. We had 3 documents that we gave out previously as samples. Now you're only going to give a sample of the offer to purchase and sample of the professional services disclosure. The document that's missing is the questions and answers on home inspections. Don't know why they took it out. Other than the fact that it's not a document that comes basically from the real estate, the North Carolina Realtors Association. I need to find out why they took it out, because I think it's a good form. But anyway, you only have to present 2 sample forms now. And the reason you have to do sample is nobody can use those forms other than realtors, okay? So if you give a copy of an offer to purchase to someone so that they can review it, it must have the word sample either as a watermark or up in the right-hand corner, on each page, write the word sample if you don't have a one with a watermark. The sample ones are available. In fact, that's the one I pulled up a while ago for you. But I would keep, I usually keep a folder of samples right on my desktop so that I can readily get to those if I need to. A home warranty. The home warranty companies do offer a fee. I think somewhere like $75, maybe $100. But there's been so many RESPA violations, so many RESPA legal consequences that we as a firm many years ago decided not to put ourselves in that position. So we do not collect that or accept that fee. So in this blank right here, you're going to put NA, okay, right here, that'll be NA. The confidentiality of offers. When an offer is given to a listing agent, that listing agent cannot shop offers. That listing agent cannot use any terms on your offer, your buyer's offer, nor can you. There is a confidentiality until it's closed. At the time it's closed is that public knowledge I talked to you about a while ago. But until it's closed, that has to be kept confidential. That's another reason that we are not in favor of using what's called an escalation clause, because we would have to show offers, and we cannot do that. We cannot show the offers without the written permission of the person making the offer. And why would they do that if they're in competition with somebody else? Okay, so just make sure they understand there is confidentiality. On this little section right here, but the only thing I see on that is occasionally they would make a note that they're related to the agent. You know, let's say it's your grandmother and you're selling your grandmother's house and you're, you know, or you're helping your grandmother buy a condo because you sold her house. Then in this area right here is where you would make a note that the agent is related to this buyer. All right. Now, this is the change I wanted to show you. And again, I think it's a really good change. They reworded the dual agency section, which I want you to read through all this, but basically it says what you know already, but they kind of reworded and made it a little simpler. This section right here is the one that I really want you to pay attention to, is the designated dual agency, okay? Designated dual agency is when the firm is a dual agent and there are two agents within the firm that are going to represent the buyer and the seller respectively. And then just as this note says right here, one of them cannot know too much about the other either. Sometimes it's the firm, me primarily as Vic, who will designate another agent to represent, let's say, the seller or the buyer. Most of the time, what we have in our scenario is, you know, we have a lot of listings and we have a lot of agents, a lot of buyers agents. So it's very often that we will have the firm as a dual agent, and we have a buyer's agent who is already in an agreement. They're going to show a Valentine listing. They're going to make an offer on that Valentine listing, and they are already designated by our firm as designated dual agents, because the buyer already has an agreement. Obviously, the seller's already given an agreement to the one who's listing it, and that puts us into that dual agency situation with designated agents representing respectively the buyer and the seller. You see that in a lot of in other scenarios where the firm might not be quite as large. They may have a smaller number of people, and in fact sometimes they can actually even go outside the firm to designate if they don't have someone else who might not be familiar with the property. But if you will, you know, read this, understand this clearly. Now you want to come on over here to the next page, and this is what changed. This pattern that we have seen probably for 20 years, or maybe not that long, a long time, the pattern has changed. And that is so that you can more clearly help people to understand that if they allow dual agency, which is this right here, if they allow the firm to be dual agents, then they have an option to allow an individual agent to be representing both. So now you're the buyer's agent, and if your buyer does not have a problem with you also being a dual agent representing the seller, then they would check that they will allow it. If they do not, which most people don't, and probably what's fairest is that they don't allow the individual to be the dual agent. The firm is the dual agent. The individual may be a dual agent, but in most cases, each party wants their own representation, right? So they've now clarified that with the buyer, and the buyer's agent knows more clearly that they do not want you representing somebody else. And this is a little bit more explanation as to that effect. Whereas in our market center, we already have made the determination that if there are two agents involved, they will represent them respectively, the buyer and the seller, as the buyer's agent and the listing agent. Okay. Now, see this little or stuck out here? This is all about dual agency. This is about designated agency. But down here, it says they want exclusive representation at all times. In other words, no other Valentine, anything. It's you and Valentine, KW Valentine representing that buyer, and you must have a cross sale agent to be doing a transaction with. Okay. We don't see that much, except when the people don't understand that they have a right to do the designated. This is if they won't allow a buyer to have anything to do with another buyer, with our Valentine listing. Okay. So now, having said that, when you fill this out, obviously you want to point these things out. And if at that time they think they want, maybe they think they don't want an agent representing both sides, you can always go back to them before you present an offer. Okay. So I don't think it's set in stone. It can be changed if the buyer is willing to. The next thing is the buyer agent compensation. If it's a dual agent compensation, we typically are going to ask for the full 6%. Again, that's just kind of typically what we've done. The main thing you want to help the buyer to understand is what is offered by the seller to the listing agent and to the buyer's agent. If you were the individual dual agent, you would still expect that full amount. But I got to warn you, you don't get it. Most of the time, that's the reason they would work with you in that manner. They want to save that amount. So if you get in that situation, give me a call and we'll kind of talk through it. Okay. Now that is primarily what I wanted to show you on the buyer's agency agreement, mainly because of the changes. Okay. Now, one thing you do want to point out, obviously, not one thing, but primarily I want you to not overlook this wire fraud warning. Everything has to be verbal. Just don't do anything in email. Just don't. In fact, I was worrying the other day. I wonder if they're gonna start hacking into texts. I don't know, but make sure on this wire fraud warning that you point that out to them again as a warning. And again, on this information, remember I told you a while ago that they can contact the real estate commission and get some of these brochures. This is where they're putting it up right here. They are available free of charge on the commission's website. So they can order them themselves if they want them, or you can get it for them. And again, on the buyer's information here, make sure that you do fill this out. Do not fill it out on the offer to purchase, but do fill it out on the agency agreements, because every now and then we need to get in touch with them, and especially if there's an earnest money dispute. So make sure they do fill this information out. And here's your entity buyer. If that's an LLC, you would fill this out. The buyer would not sign up here. The buyer would only sign down here, whereas this is the entity buy, and this is the buyer's, the physical person's name right here, the signature and in the name here, and make sure you get the title, okay, on here. And the bottom is where you're going to put the name of the firm. The firm's number is capital C 13291, capital C 13291. That is our firm number with the North Carolina Real Estate Commission. Then down here, you sign it. I don't know why they don't want your signature, why they don't want your name, but to get your signature and put your license number right here, because you're doing it on behalf, obviously, of the firm. Well, that got us through the buyer's agency agreement. So now let's see what we can find, if I can find the offer to purchase, okay? Because we definitely want to go back and get that. The offer to purchase, that's the new one. Okay, come on, don't do that for me. This is your 2T right here, the offer to purchase. Let's see, maybe I have this one highlighted. Let's look at it. I do. These are the changes that were made to the offer to purchase. That's highlighted, kind of call our attention to it, okay? Again, the offer to purchase, you put the seller and the buyer's name. Try to get the legal name. The attorneys really appreciate it when you get their legal name, even if you have to ask for the driver's license. Ask for their legal name so help if we haven't had two different instances where the spelling has been wrong that they were given by a spouse generally in both those situations. So that's why I said, well, maybe you look at the driver's license, okay? So anyway, get the legal name if you can, because the attorneys want it. If they say their name is Bubba Smith, you put Bubba Smith down there, it'll be fine as far as the legality of the contract. Again, you're just trying to be helpful. But see this little section here? They divided that out to make it prominent that the property will or will not include a manufactured mobile home. If it does include a mobile home, whether it's the main residence or maybe it's a residence they had for a parent-in-law or whatever, you know, on the property, or it might have been used for a different purpose. If there is a mobile home on the property, use this form, the additional provisions addendum, and that's the number on it right here. It has a section that asks for the VIN, VIN, that's the vehicle identification number with the was it Department of Transportation? No, Department of Motor Vehicles, that's what it is. Because if it is a mobile home that has not been detitled, then it's like selling a car, and you can't sell a car. So you have to have it detitled. Sorry. So make sure that you use that addendum. Oh, excuse me, just a minute. Okay, you're not going to have as many issues with that. Let's scooch on down here and look at this next change. I skipped over this, and I probably should not have. When you're writing your offer, make sure that you print out the MLS listing and the tax records, because what you're going to do in this little section, wait just a minute, this little section here, you're going to verify with the tax records that the information on the MLS listing is correct. And every now and then you'll have a discrepancy. Again, we've had one in the last week where there was some discrepancy, and they're having to go back to the tax assessor's office and get some information corrected. So you want to make sure that it's the same property. The most important thing you can find out about is the property ID, that parcel ID, and that's this right here, that parcel ID. It'll be listed in the MLS, but make sure it's the same parcel. And you know, one of the nice things about the way Canopy has it set up is that parcel ID is hyperlinked, you know, blue underline, and you go right into the tax records directly to that property. And so it's easy to find and easy to verify. All right. And make sure you get the deed book and page, because we do keep records by deed book and page in our area. We do not do by plat. In some areas they do by the plat, but in our area it's by deed book and page. Right here, obviously you're going to put the purchase price, and remember, this is just arithmetic right here. This is not complicated. If you're going to offer $300,000 and you're offering $10,000 in due diligence fee and maybe $500 in earnest money in our offers lately, then you're going to take $10,500 from that $300,000, and down here you're going to have your balance. This does not have anything to do with finance, doesn't have anything to do with down payment. This is just the simple arithmetic of what is offered, what is being paid up front before closing, which would be typically an earnest money and due diligence, and just minus that out and come down here and do the arithmetic. Okay. You probably aren't going to have most of these, but these first two are the ones that you're going to have the challenge with. Primarily the due diligence fee. In the last year's form, they included this thing right here, electronic transfer. Whereas the due diligence fee is due on the effective date delivered to the seller. it's kind of hard to do that. A lot of you doing these effective dates at 10 o'clock at night for one thing, but the other thing is it's kind of hard to be able to get this monies and be able to give it to them even within a 24-hour period. All right. But that's what the form writers expect for us to do. So they included not only the wire transfer, but they included the electronic transfer. Now, the electronic transfer, that would be your Venmo, PayPal, Zelle, the monies that you could transfer electronically. If your buyer prefers to transfer it by one of these electronic means, you need to identify which one, and that's where you're going to fill in this blank. Now, let me show you something else. Let's just hang in there a minute. We'll come back to that. Let's go down here to the next page, top of the next page. If the parties agree that the buyer will pay any fee or deposit described above by electronic, and look here, they've added or wire transfer. They've added it. Seller agrees to cooperate in effecting such a transfer. What has happened is that if the seller agrees that he will accept a Zelle transfer, let's say, but he doesn't have anything, he doesn't have a Zelle account. I mean, obviously they're easy to set up, but he hadn't set one up. By agreeing to this contract with that provision, he has agreed that he will set the Zelle account up to receive the money in that manner. The wire transfer has become a different issue. We have had such high amounts on the due diligence fees. You can't transfer them electronically through Zelle or Venmo because they have daily maximums that you can transfer. Well, you can't very well. Last week we had one was $100,000. Well, how are you going to get $100,000? In fact, I think the contract was written on a Saturday or maybe Friday night or Saturday. They couldn't get an official check until Monday. So there's a way you cannot obviously get it to the seller unless you wire, and really you can't even wire on the weekend. But nevertheless, the point is the seller has to be agreeable to receive the funds in the manner they agree to. And if it's a sizable amount like that, about the only way they're going to get it is through wire transfer. And sellers obviously are apprehensive about giving someone they don't have any idea who they are, or they've just seen an offer come in with their name on it. They're apprehensive to give their routing number and their account number. But at the same token, sometimes that's our only option. So with working with the buyer's agent, listing agent in between, they might be reluctant, but that is the way they get the money. And that's really what happened the other day on this one, that in order to get their $100,000, they had to produce their wiring information. So just be aware of some of those little practical things that you have come into play when you're trying to get the due diligence fee to the seller. Now, sometimes the due diligence fee might possibly be delivered by FedEx. The thing you're going to have to impress, and I don't know what you're going to have to do to make buyers understand it, but you better be doing it, whatever it is. That due diligence fee has to be paid, and it needs to be paid immediately upon either with the offer or upon everybody signing the offer. It is to be delivered. It is not their right to put it in the mail. Okay, we don't accept, nobody accepts in the mail, because mail can take 11 days to get across town. So they can do a FedEx, UPS, and USPS now has a tracking system, as long as you can provide a tracking number that will indicate to the seller it is in the mailbox, it is en route. Again, not too long ago, we sent FedEx on a Friday and they didn't get it till the following Tuesday with overnight delivery paid for. Okay, so it's not a guarantee, but it's as close as you can get, unless you can make sure that the check is delivered personally. Now, if for whatever reason, let's say the buyer goes ahead and gives you that check when you're writing the offer, Not likely, because you're probably having the offer signed online, aren't you? You know, so, but let's say they do. Then let me show you where you want to make sure that you have a receipt. It's the last page, and gosh, you know, we got 16 pages now to our offer. They added one more page. There's a signature page right here, receipt of monies. If for whatever reason you agree to deliver that check to the listing agent or get it to the seller, right here is what you've got to get signed by the listing agent that you indeed delivered it to them. You don't have to sign that you got it, but you want to get rid of that hot potato pretty quickly and make sure that it's timely delivered to the listing firm. The agent themselves do not have, I mean, the individual agent doesn't have to sign it, although often we meet in the Harris Teeter parking lot and give it to them, but the firm can sign for it. So if you have no other means to get it to them, make sure that you get a signature here. If the money is wired to the agent, I mean, excuse me, to the seller, or if they receive it in some other way, you need a signature right here that they have received that that money. All right. So these are receipts or acknowledgements, and you do need to get those. When the earnest money is delivered to the attorney, again, this is where you want to send this over to the attorney, or an email is sufficient from an attorney's office. It's going to be noted, you know, obviously it's coming from the attorney's office, and they just need to confirm that they got the earnest money. Okay, now let's go back up to page 1. We don't get off of page 1 too quickly, because there's a lot of businesses that's going on there. Okay, now this is the change. Up until this version, we had the option of giving the earnest money at the time we get the executed contract, just as the due diligence. They've taken that out because most people do not use it. And now the only option is that the earnest money would be delivered to the attorney's office within 5 days of the effective date. And again, the effective date is defined on the next page as the date that the last party has signed and made it a contract. And you see, the earnest money can also be given as cash, personal check, official bank check, wire transfer, or electronic transfer. And it must be done within 5 days. All right. Do not accept cash. I don't know why they even put that in there, to be honest, but don't accept cash. You can't make copies of it. It's illegal. You like to have paper trails. All right. Suggest they go across the street to the 7-Eleven and get a money order if they don't want to give cash. That's the surest way of getting some paper trail. All right, let's scooch on down here now. Whoops, went too far. This basically explains where the money is going to be deposited, which escrow agent. Very few firms are holding earnest money any longer. It has become a standard practice that the trust accounts are maintained by the attorneys, and our firm has opted to do that as well. So if you're writing an offer for a buyer, then you're going to recommend an attorney. They may or may not know closing attorney. If they don't, I would suggest that you might want to say to them, well, I can give you a list of attorneys and you're welcome to check it out, but we need to put somebody's name in here. And you can change escrow agents. All right. Right up front, I would suggest that you go ahead and put McNaught and Clements, because they're so easy for you to get to, you know, or for the client to get to, because they're right there on our floor in our office, and very, very nice to work with, by the way. But the buyer does not, the buyer, if they elect to have a different escrow attorney, even after the escrow has been deposited, that is allowed. Okay. I'm not going to pull the form up for you, but make a note to pull up 4-T. That is a change on the agreement to amend that little form. Oh, I love that little form. It's used in so many ways. And now they have added that option of transferring if for whatever reason the buyer would choose a different attorney. Don't have it very often, but they need to know they have the option, because you're not telling them who they have to use. You're only giving them an option at this particular time of maybe using one that's convenient for you. Okay. All right. This little section here, if there's a dispute on earnest money, there are several instances or provisions in our contract that will say the buyer gets a refund of their earnest money, not due diligence, but earnest money. All right. When you talk about due diligence, say, you know what, you just want to kiss that money goodbye unless you close on it. Because when that check is given to the seller, it has the seller's name on it, and that money belongs to the seller until they see it closing, and you have a credit of that amount of money on the closing statement. So you can make light of it, but it's very serious that people understand. The due diligence fee is a fee that is going to be not disputed. Earnest money often is disputed. And if it is disputed, it has to be settled, either negotiated with the parties and they come to an agreement, or the money then is deposited in the court of the county where the property is located. And the parties then have to go to court to actually resolve it. And then a judge will tell them how they'll resolve it. And that's basically what this says right here. Okay. These paragraphs are definitions of the term effective date, definition of the term due diligence. What does the due diligence fee mean? What's the definition of it? It's right in here. Now, the due diligence fee has become the prominent player in this whole thing, in the multiple offers situations that we've dealt with now for the past year. The due diligence fee is what makes or break an offer. There's not been too many ways to break, to make your offer stand out other than offer more due diligence fee, so it's in the seller's hands as soon as they get the offer or that day. So just make sure that they understand that the due diligence fee is for one purpose. It is to buy the right to terminate for any or no reason during a period of time, which we call the due diligence period. And right here is where you're going to put the date, the end date of the due diligence period. It ends at 5 p.m. on July 30th or whatever. Without them paying a due diligence fee, if that's what's agreed in the offer here, without them paying it, they do not have a right to terminate during that period. Most people think, and so help me, in the last week, we got a letter from an attorney who said the due diligence period is for inspections, and because the buyer didn't inspect, they just didn't pay the due diligence fee. They should be they shouldn't be held accountable to pay the due diligence fee. And I'm saying, you're an attorney? What school did you graduate from? You know, the due diligence fee is not for inspections. The due diligence fee allows them the right to terminate for any or no reason, period. Yes, during the due diligence period, they have every right to inspect any and everything they want to inspect. But the due diligence fee is not what allows them the right to inspect. If there's no due diligence fee written on on page 1, and the seller accepts that contract with 0 due diligence fee, then that's the contract. They can still inspect, they can still ask for repairs. And again, that due diligence fee pays the right to terminate the contract. And how many times we've chuckled, people aren't concerned about the contract. They're just concerned about they get their money back. You know, I said, you know what, you might better be looking to see what that contract says, because it's more than if you get your money back for this particular scenario. So this wording, I want you to be real comfortable with, okay? Make sure this is, so you see this, they've created a legally binding contract for the purchase or sale of property without regard to the existence or amount of the due diligence fee. That's what I was just saying a moment ago. It can be little, I don't know, it could be large amount of due diligence fee, but the purpose is for them to have the right to terminate. Okay, that you're going to determine. When we first started, or for years, the due diligence period, we were looking at about 21 days in order to be able to get our inspections done and the buyers to be able to determine that they were ready to move ahead with it. Again, the due diligence fee has significantly increased and the due diligence period has decreased, which is a way the buyer saying, I'm going to buy this house. I'm not even depending on inspections. I want a period of time that I will get some inspections if I can get them done during that time. But if you'll choose my offer, I won't hold the property off the market any longer than it needs to if I decide to terminate. Okay, now this next paragraph is where, oops, the settlement date. The settlement date is the date that the attorney has them come in and sign all the papers, whether it's loan papers or whether it's the deed. All right, that is considered a settlement time. In North Carolina, there are 4 things that have to happen before a property is considered, a property transaction is considered closed. You have to have the settlement time, the settlement date where all the paperwork has been signed by all parties. The title company, the attorney, will run one more title search just to make sure that there wasn't some lien that popped up in the meantime from the time he ran that first title search. And yes, we've had that happen too. So what happens is the settlement happens, then the attorney runs one more title search just to be sure. The lender releases the funds based upon that information. Once the funds are released, then the attorney has the deed recorded at the Register of Deeds in the county where the property is located, and it is then considered closed. 4 things, and those things must happen. The recording of the deed is obviously the best because that's the final step. And the attorneys then have assured you that the ownership has transferred by that when it's recorded with the Register of Deeds. So you want to put this date here as the date that they're going to meet with the attorney and sign all those papers. Sometimes they meet separately, you know, sometimes there's mailaways, there's different ways of having the settlement date, but just make sure you work with the attorney early on as to how your buyer, if they're going to be showing up for closing or if they're not showing up for closing, if they need to mail away, then I just said the word closing, settlement. I've been in real estate a long time, and closing comes so natural for me to say. It's the settlement that you have to work with the attorney on. Now, notice this right here where it's capitalized and bold. In paragraph 12, there is a provision that if for whatever reason the settlement date cannot produce all the documents, the parties, and they're not called buyer seller, they're calling delayed and non-delayed party in paragraph 12. The delaying party has up to 7 days whereby they can produce all those documents and signatures. Up to 7 days. The non-delaying party is not going to be happy because they probably schedule movers and they probably made plans based upon that date. So buyer's agents, as soon as you know that might not happen on that date, please be in touch with that and be courteous enough to let them know that it looks like it's going to be a 2-day delay. That's just the right thing to do. All right. Legally, it doesn't tell you to, but you need to. Yes, you do have 7 days. There is a word in that paragraph 12, and it says if it's not possible to close that day. Not possible means that there's a third party that's preventing it, such as the lender, or maybe it's the title search. Something had to be cleared off the title. During COVID, the offices were closed at the Register of Deeds and some of the places that were needing to be open to conduct business. So if it's not possible, it is not, it's generally a third party. The issue of a buyer and or a seller just not being ready, just not, for whatever reason, they just didn't get packed. They just didn't count on that date. That's not being possible. That's a personal choice. We've had the situation where a buyer or a seller had a vacation plan and it was paid for, so they were going to take that vacation and they just figured they'd have their 7 days. They knew when they signed that document that they had paid for a vacation and that date would be in. So that could be considered breach of contract if they went to court about it. All right. So keep in mind the being possible typically is not a matter of choice by either party, buyer or the seller. All right. Now, this has become a real big boogeroo the last year, special assessments. Special assessments is going to have to be already levied against the property. And what our present contract is saying is that the buyer, that's one of the things the buyer has to do during the due diligence period. They are to determine if there are any special assessments. But let me tell you, it's very hard for a buyer to do that. So you are going to be involved in finding out if there's special assessments, whether it's a special assessment by the HOA or if it might be a government thing. Maybe it's streetlights in the neighborhood, whatever. But make sure special assessments have to be paid by the seller if they're already a special assessment. All right. And this is another paragraph in the contract, but just so you know, it's the buyer's responsibility to find that out during the due diligence period with your help and assure the buyer that if there is a special assessment, that is to be paid by the seller. All right. Let's go down here now to the fixtures. Oh my goodness gracious, you cannot believe. And again, I have a story just about every day on the fixtures. Fixtures, I think you learned in pre-licensing, I bet you. The fixtures are things that are screwed, glued, nailed, not nailed. What's that other word? There's 4 words. I can't even remember the 4 words. What I remember is if it causes damage, to remove it, that's a fixture. All right. So if it causes damage, it's a fixture. And we have a massive list here. You'd be surprised how sellers sometimes don't understand what things are supposed to be left, and poor buyers are saying, but the contract said it's supposed to be left, and the seller's thinking, well, it's my refrigerator. I think I'll take my refrigerator. And you know what? If it's not in the contract, they have a right to do that because a refrigerator is a personal property. It's not something that causes damage when it's moved, right? All right. So these are the things that are listed in the contract that are accepted and expected to be a fixture. All right. This one right here is a bigger. This alarm and security systems. You know, there's hardly a house out there now that doesn't have a security system. Houses they're built with security system built in. So it's not the system. You know what the issue is? It's the service contracts and it's the accessories to those alarm systems. So security systems. So you want to have that talk with the buyer, and listing agents better be having that talk with the sellers. A service contract is an outside contract. It is not anything to do with the real estate. It is a service contract that the seller is obligated to pay. The buyer is not obligated to take that service. Most of the time there is a transfer fee, even if they do, okay? There's no reason why they can't do it as long as they're willing to pay the transfer fee, but they need to know if they choose not to, the seller has to pay an early termination fee with the service company. So again, the system itself is an attachment. It can't be moved, but you need to take the next step further and find out what to do about that service contract. Okay. Thing we've run into with the alarm system is they have accessories. I think it's an accessory when you open the front door and somebody says door number 1 is open. You know, there's this recording that comes out of this thing. There are several accessories. They can be removed. And I think one of the sweetest things, I had this little older gentleman call me one day and he said, ma'am, I think your listing agent didn't do their job, and they let the seller take my security system. My door doesn't talk to me anymore. And I thought that was so cute. His door doesn't talk to him. So, but that's an accessory. So make sure if it has some accessories, those don't stay with the property. Obviously, carbon monoxide and smoke detectors, all of those do stay. Okay. Another provision that's a little different from my definition of a fixture, if it causes damage, is stoves. For years, we had arguments about whether one of those a freestanding stove, you know, that just slides in the slot for it. Then now they put in here, all stoves stay. It doesn't matter if you can slide it out or not, all stoves stay. Gas logs, another thing, people were taking gas logs. No, you can't take the gas logs. They are fixtures now. Garage door openers, and all the trinkets that go with them stay. Over here, one of the things that they added recently or last year, storage shed and utility building. When you're walking through that property and you see that storage shed out there, you want to point it out to them that according to the contract, that storage shed is going to stay, but you will be glad to confirm with the listing agent that the seller understands that, because according to the contract, it's supposed to stay. Maybe your buyer doesn't want that dilapidated old shed out there. Maybe they want it moved. So you need to figure out how you're going to get it moved, because the contract says it stays. All right. This was added. And again, this is so many arguments through the years. This was just this contract: window and door blinds and shades, curtain / drapery, rods and brackets. The rods is what people were taking. They'd leave the brackets and to take the rods. I understand that potty barn rods are pretty expensive, so you want to make sure. And I want you to know that a curtain and a drapery are the same thing. It's just different words. Drapery is a more formal curtain. So they've now added the word, again, I've got a long story to tell you about that. A curtain and a drapery is the same thing. So make sure the rods and the brackets stay. A TV, the TV can go, but the TV mount is an attachment. The TV mount stays unless they say, so the seller has said, I'm taking my mount for my TV. If that is the case, in the MLS, there is a field for exemptions, and it should say TV mount in family room is an exception. In other words, it's not going to remain. And if that's the case, then you're going to come right down here in this little section right here, items that do not convey. That TV mount in the family room will not convey, where you're going to accept, the buyer understands that and accepts that. This little section right here has to do with things that are not owned. And one of the changes that we have in this contract has to do with fuel tanks. My goodness, you wouldn't believe what the major provision in the contract they've made for fuel tanks now. It must have been a real big issue this year. It has been in years past, I can tell you. And I'll go through that in just a moment with you, but just to say to you at this time, you're not going to have a section in here about fuel tanks. Fuel tanks typically are leased. And so therefore, because they are leased, they would not convey. And typically you would have put that listed here, but in this new contract, you don't. And then they've made a note here that leased fuel tanks obviously do not convey. And see this little pretty poor little lost sentence right here. Seller shall repair any damage caused by removal of any items excluded. Remember I told you my definition that causes damage. Just make sure that you understand that the buyer has a right to have that fixed as if it has never been there, if they do take something. Okay. Personal property. Personal property, primarily, you're going to see a refrigerator, maybe washer and dryer, but definitely refrigerator. If refrigerator is listed in the MLS as conveying with the property, that doesn't mean that it has to stay unless you write it on this contract. Like they say, what's within the four corners of the contract is what's legal. Even though it's advertised that this refrigerator stays, you have to write that is going to say, because it's personal property. Same thing with washer and dryer. Okay. You typically are not going to put other things here. And I know there's quite a few lines here. Lenders do not want to see that they're going to leave their bedroom set or their patio set or whatever. Lenders don't want to see that there must be some value there, even though the value is at zero. They don't want to see that. So just be real cautious. If there's some other furniture or whatever that they want to sell, you primarily going to do that just like they would sell it on Marketplace or Craigslist or whatever. It's a person-to-person agreement. It's not part of the sales contract. Or you can talk to the lender, and if the lender says his underwriter will approve it, I don't have a problem. But lenders are the ones that you got to have a problem with. And again, right here, they point that out in this note here. This is several paragraphs about due diligence. All right. And you can see there's some bold words, there's some capitalized words, there's the warning. In other words, be very serious and help them to understand what due diligence is, what due diligence is for. And this reinforces what we talked about earlier. And I'm not going to go into details too much more on that. Let me show you. You want to point this out. There is no loan or appraisal contingency in this offer to purchase. Buyers have a hard time accepting the fact that our contract does not have a provision for if the loan is not approved. So make sure they understand that has to be done during the due diligence period to the degree that the buyer is comfortable to move forward, or they would need to extend the due diligence period, and hopefully the seller will do so. They don't have to. Okay. Now look at all these things that the property investigation, there's a number of things that the buyer has a right to inspect, to know about. They need to find out if they can get insurance. Don't let a buyer try to get his insurance 2 days before closing. It is not going to happen. So a couple of weeks out, make sure that they are checking out the insurance on that particular property. If they're going to have an appraisal, most of the time, if they're getting a loan, they're going to have an appraisal. So they need to be working with the lender on what type of appraiser. Sometimes they're doing, there's like 4 types of appraisals can be done. Sometimes they can do a desktop, sometimes they can do a drive-by, or they may need the full appraisal. So just talk with them, have them talk with their lender, because their lender is going to coordinate all that. Make sure about the utilities and the access. Our form that we use is the septic or sewer and water disclosure, the agent discovery form that I have you all do. That basically is to give them confidence about this, whatever type of the source of their utilities are. Try to get your listing agent to give you a list of utility companies that that apply to this particular property. Find out if they have trash service they have to pay separately. Try to find out as much as you can from the listing agent, and then you might still have to do some research on your own, particularly if it's a community well or septic system. Make sure that you can provide that to your or help your buyer find that out. And again, look here, there's that special assessments that was added. I told you they added it. That is a buyer's responsibility to find that out, to confirm that. This right here, this next section basically is to remind the buyers that the property is being sold in its current condition. The seller may, but is not required to even engage in trying to negotiate repairs. That is very foreign to a lot of people who buy and sell, or maybe in other states, it is very foreign to them. So just to know that the seller does not even have to respond when you send over a due diligence request. And generally you have to get the listing agent to tell you they're not going to respond, but they don't have to. Just so you might want to point that out to them. Okay. Paragraph 8C, access to the property, and paragraph 8M for negotiated repairs and improvements. The times that you can have access to the property, you obviously have to make an appointment. Sometimes there may have to be confirmed, but that you have to make an appointment to have the inspections done. So you should have a right during the due diligence period to do any and all of these inspections. And before I mention inspections, make sure that you get the CCRs. If there is an HOA, you can, hopefully the listing agent has done their duty and put it in with the listing. But you want to make sure that the buyers have that. They should have the CCRs, deed restrictions, bylaws for the HOA. They should have the residential property disclosure. They should have the MOG, unless they're exempt. They should have those, and possibly the lead base, we said earlier on. These are things that when you write the contract, the buyer has a right to have available those documents so they can review them. Again, they only sign that they have seen them. They don't have to agree with them, but do your dead level best to get it in their hands prior to writing this off of the purchase. All right. Now this right here is the wording or the paragraph that explains, as I said before, the reason for the due diligence fee is to be able to terminate for any or no reason. And it has to be done before that date that we put in due diligence period. And see this little phrase here, time being of the essence. That's the only time of the essence on the date in this contract, except if there's additional earnest money, but you rarely ever deal with that. This is the big key. This is the thing that you have to keep in mind at all times, and everything has to be timed around that date. And don't wait until 5 p.m. to terminate a contract. You as an agent are the one who's going to drive their decision on whether to proceed with expectation of closing, or if they don't have a comfort level, they need to terminate. And your verbal discussion with the other agent doesn't count, guys. It has to be in writing, and it needs to be sent by the buyer's agent prior to 5 p.m. on that end date. Now, they did clarify this last year that it does not have to be received before 5 o'clock. This past year, they clarified that if you can show proof that you indeed sent over a written termination, and the termination form that you would use is form 350, where the buyer is terminating because of the option due diligence during the due diligence period, then if you can show that proof, then your buyer is entitled to get the earnest money not the due diligence fee, the earnest money. If you don't get it there before 5 o'clock, he's most likely lost the earnest money in addition to the due diligence. Okay, so be very focused on that date. And if you're working with more than one client at a time, you better be having some reminders and some notifications on that phone to keep you focused on that. Okay. All right, let's scooch down here now and take a look at number 5. The buyer represents that they can pay cash. Woo! And more people are paying cash right now. Surprisingly, I don't know where they're coming up with all this money. They can check this option right here that they intend to pay cash, and you'll see that they've noted a choice or an option here. Verification of cash available for settlement is or is not attached. Verification meaning proof of funds. And you see this little note here, it's telling listing agents and sellers, you probably don't want to sign this until you've seen proof of funds if it's a cash offer. All right. Then you come down here, and this is where you're going to state, and it's really for information only. You're going to the buyer's intent of getting a loan, and that intent of getting a loan, and you're going to put the information in here so the seller knows what's going on, but it's not, the contract is not contingent upon that buyer getting this particular loan. This is strictly for information and strictly to give the seller the confidence that the buyer is in process of getting a particular type of loan. They're going to feel more comfortable if that buyer is going to put 20% down on 80-20 loan. They're going to feel more comfortable that that buyer has the funds to possibly get this thing closed. So sellers do look at it, but it doesn't protect the buyer. That's what I'm saying. Now, the one thing you do need to be aware of, if your buyer is going FHA or VA, there is an addendum, an FHA VA addendum that should be given along with the offer, because the seller might need to know that an FHA appraisal is going to be done. And if the house doesn't appraise, the buyer then, because of this addendum, would be entitled to get his earnest money back. Again, not due diligence, that's a fee. So the seller needs to be aware of what type of loan, and to make them aware, the FHA VA addendum is accompanies the offer, because it's an addendum to the offer. And if the seller agrees, the seller also agrees to the fact that they understand that the property has to appraise for the sales price that's on the contract. Okay, so make sure you do have that in place. Now, we do not have in North Carolina, we do not have such a thing as a contingency on a sale of another home. In South Carolina has, and many other states would have an addendum that would say, if you can't sell your house, then you don't have to buy my house. North Carolina does not have that. They eliminated it about 3 years ago. Now, the only thing that's in this offer to purchase is this section right here. They do or do not have have to sell or lease a property before buying this one, or acquiring a new loan. That's what normally causes the problem, because if they can't sell the house in, let's say in Michigan, they can't buy the house here in North Carolina because the funds are tied up in the house in Michigan. And that's where buyers do not feel like that's quite fair. And yet the seller will say, well, what's not fair about it? I thought I was going to sell my house in the last 3 weeks, and now you're telling me your house in Michigan didn't sell, so I can't sell my house. So the form writers went to the due diligence concept again, that if during the due diligence period, they have a copy of the house does go into contract in Michigan, then you can give a contract to the seller. You can share the contract if it's already under contract. You can share that contract with you with the sellers when you make the offer. However, it hasn't closed yet, but just make sure that the buyer understands this contract is not contingent. No matter how much information they give or how much money, information they don't give. But I would suggest that it's probably better if there is a house to sell to go ahead and be upfront with the seller that there is one. And obviously you have to tell what stage it is in selling that property. This is again a warning that it's not conditioned on that. This right here, I highlighted that again. This wasn't a change this time. It was just basically formatting, and for you all to be aware that residential property disclosure is required prior to writing the offer. If indeed it is not given until after the offer is accepted and you've got a contract, when it is delivered, the buyer would have a right to terminate. And looky here, this is one of the very few times they would have a right to get the due diligence fee back. Isn't that interesting? If for whatever reason they don't get it within the 3 days, or if they read it and they're not pleased with it, then they would have a right to terminate. And in my 40 years, I think we've had 2 times that someone has actually used this, but it is a valid way for someone to get out of a contract. And as I said, notice here, they have added that they would get a refund of the due diligence fee. So make a note to self. All right. Make sure they get the residential property disclosure, and make sure they get the mineral and the oil and gas rights mandatory. And again, that's a form that's only North Carolina that I know of. Make sure that they get that if it is applicable. All right. The buyer's obligations. This was something that's new in here. They've atomized, and I think this is kind of interesting. They've atomized the things that the seller, the buyer can expect to have to pay. And the seller and the buyer, they've itemized it as, which I think is very helpful. This right here is a little different. The buyer is obligated for charges by an owners association or management company as an agent of the association under paragraph 9B of this contract. 9B is where they itemize these things out. Every now and then a buyer is going to have to pay some fees, and they're just making sure that if those fees that are required by the owners association would be paid by the buyer. There's nothing that changed basically in all this. Let me go scoot on down to where there were some changes. I wanted to point that out. Whoops, there it is. There, I told you they put a whole bunch of stuff in there in the fuel tank. All of that is about fuel tanks. Lord have mercy. You can tell they've had a lot of problems with fuel tanks. Now, and this is a major change, up until this contract, the seller would have a right to sell the fuel back to the fuel company up until the time of settlement. And at that time, if there was any fuel left in the tank that had not been sold back to the fuel company, the buyer, it would be the buyer's property. Most sellers were selling the fuel back. You don't take fuel out, you just sell the amount of fuel back to the fuel company. And then up until this contract, the fuel company would come out and put a lock on it. And the buyer couldn't use the fuel until they went into contract with the fuel company and paid for the fuel. And that way the fuel company were getting a client. They have removed that now. The buyer is going to have the right to have the fuel that's in that tank. All right. The seller does not have a right to sell that fuel. The right here, make sure it says the seller's use of the fuel in any fuel tank is subject to the seller's obligation under paragraph 8C. This is where we were running into problems. The seller couldn't sell the fuel because the seller had to make the fuel available for this final walkthrough. And it was a timing issue. All right. The fuel company couldn't come out and put the block on the fuel because the buyer hasn't done the final walkthrough. And that is one of the rights and privileges of the contract. So now they're basically saying the seller, what fuel's in there goes to the buyer. The seller does not have a right to sell it. These are the, they have 2 tanks. I don't think most people don't have but one, because many times it's just for the gas logs. But nevertheless, there are some houses that are heated by propane. Excuse me. So you've got some information about the fuel tanks here, one or both. And it says, and the tank itself, most of the time, is not owned by the seller, but it obviously gives you to the option to know if it's owned by the seller or owned by the fuel company. So you want to take note of all this, because that's a lot to take in, but basically it's what I just told you. But that's the biggest issue, that they really made a change in this whole contract. Let's go on down to, this was one of the things that they pointed out to us, to say the buyer's failure to conduct a survey or examine title of the property prior to the expiration of the due diligence period does not relieve the seller of their obligations to deliver good title under this paragraph. Isn't that interesting? The seller would still be required to clear the title in order to close on it. So make sure that, you know, that again, that's a timing issue. Sometimes they can't clear it out during the due diligence period. So, but the seller is still obligated to take care of that. Now down here makes a note about the owners association fees. The seller shall pay any charges by an owners association or management company as agent of the association under paragraph 9A. This is what I told you a while ago. The special assessments must be paid by the seller, and any charges that would have been assessed by the HOA, that would be the seller's responsibility. And again, it talks about that a little bit more in that paragraph. Home warranty. This is, I'm not sure exactly why they said there was a change. I don't see a change in this, but anyway, they said there was a change. I think what they basically were wanting us to know, that they did put a note that sometimes it's better for the buyer to talk to a representative from the home warranty company that they might select. If there is anything specific they're concerned about, make sure that they do talk. I know Steve is always saying, you know, for 210, you know, have your buyers call me. I'll be glad to explain everything to them. And so use those sales representatives from the warranty company, and let them have the liability of what's being told to the buyer that they've covered. Like I said, this is about the breach of contract. In paragraph 23, they have changed that paragraph to be very clear that a buyer and or a seller now can sue for specific performance for a breach. And determining what the breach is, obviously, is one of the first things that have to be decided by or determined by the attorney. But they wanted to make it very clear that buyers and sellers don't have to put up with a breach. We've had a number of sellers in the last few months who have breached the contract and would not sell the property, although it was under contract, because they couldn't find a house to go to. They could not move their family. They did or chose not to accept what they were able to sell this one for and buy another one. And they just decided not to sell. Well, you can't really make somebody not sell, but you can make it financially feasible that they wish they had. And that's kind of where the commission is coming from, or the form writers are coming from. They do want the buyers and sellers to know that they have a legal remedy for just a change of mind, a breach. Okay. Now this is where it outlines, I told you, itemizes the seller's fees and not fees, what the seller is expected to pay and what the buyer is expected to pay. I think this is really, really good. Another thing that changed was this risk of loss. Whoops, went too far. The condition of the property. the property must be in substantially the same condition or better than when the offer was made, not when it became an executed contract. So it's very important that sellers understand that they are to take care of that property up until the time its settlement date happens. And if you, in fact, I had this question this last week, and I remember 2 years ago, someone asked, do we need to spackle nail holes? You know, when you got all those pictures on the walls and you got to do something with those, when you take the pictures down to move them, then you got all those holes in the wall. Am I supposed to do something? And I said, well, in times past, I wouldn't have thought it was such a big deal but we had a pretty nasty complaint to the real estate commission, and it cost some money to settle, because the sellers spackled all these holes from nails, and the buyer's agent said it looked like the house had chicken pox or some kind of measles or something, because you can just walk in the house, you can see all these spackle notes. They didn't sand them down, you know, they didn't paint over them, they just spackled them, and they thought they were being helpful. Well, that just meant the buyer then had to paint the entire house because they had so many spackles. So anyway, that gives me a funny picture in my mind. But from now on, I'm saying, no, I don't think you better fix those nail holes without clarification with the buyer. So that's a simple little story, but basically it said, do not change the landscaping, do not mar in any way the house that the buyer is anticipating buying by giving you that offer. Okay. Yeah, there's let's see, it seems like, yeah, this is paragraph 23. Again, this last year was the first year we had this paragraph 23, and this year they've kind of strengthened the words in it. And be very cautious of this one right here. If there is a material breach of the contract by the seller, such as what I told you a while ago, the seller decided not to sell, the buyer may elect to terminate this contract as a result of the breach and shall be entitled to the return of both the earnest money deposit and the due diligence fee, together with reasonable costs. You know, when you go into a due diligence period, you spend some money on inspections, right? So there are a number of costs that might be incurred to reimburse the buyer, in addition to giving the due diligence back and the earnest money. Like I said, those are about the only two instances that you might get a due diligence fee returned. And right here, this is, if you're going to be talking to an attorney, the attorney is going to know that, but they specifically wanted to let you know that it's part of the general statute or the law that written notice has to be given to the other party with 5 days from the mailing of the notice to pay the outstanding amount. So that is just about what we can cover today. We already, oh my gosh, I'm a little bit past 3, but thank you for your grace in trying to get this sharing to work. I don't know what in the world happened on that, but thanks, Nicole, for letting me know, and hopefully we got it taken care of. Y'all got any questions? I'll be here for a couple of minutes. Hi, Makeda. Hi, Daisy. Good to see y'all today. Hi, Carla. Well, if you don't have any questions, well, you know my email, and you know my voice, you know my phone number. So just give me a buzz, and thank you for being with me today. And I'll see you next week. Next week, we'll be talking about South Carolina listings. And then the following Thursday, we'll be doing South Carolina buyers. But again, I know I've thrown an awful lot at you. So I appreciate you being with us. You have a question, Makeda?
No, I don't have it.
No. Okay. Bye-bye, y'all. Have a good day.